walking in their shoes. The reciprocal argument rule in family law litigation. Family court is not ordinary litigation. In a business dispute, the parties may fight hard, settle, and never see each other again. In divorce and child custody disputes, however, the parties often have to deal with each other for years afterward. They exchange the children week to week, month to month, make school and medical decisions, attend graduations and weddings, and handle family emergencies. Even when no children are involved, alimony or other obligations may keep the parties connected long after the decree. The case ends. The relationship, in some form, usually does not. Yet family court often operates as if it were built for total war. Temporary orders decide who stays in the house, who pays support, who has the children when, who pays what debts, and what the family's life will look like while the case is pending. Contempt and enforcement proceedings accuse someone of violating court orders, sometimes willfully, sometimes foolishly, sometimes because the order was unclear or impossible to follow. These hearings are contentious by nature. Clients are scared and angry. Lawyers are defensive. Declarations are often written to wound, not to clarify. Judges and commissioners are left to sort through exaggeration, selective facts, wounded pride, legitimate fear, financial panic, and sometimes nonsense. So here is a modest proposal. Before an attorney argues his or her own client's position, that attorney must first state the opposing party's position fairly. Call it the Reciprocal Argument Rule. Before presenting argument on a motion for temporary orders, for example, or enforcement or contempt, each attorney must briefly and fairly state the opposing party's requested relief and the strongest good faith basis for that request. Counsel does not have to concede disputed facts or legal conclusions. This is not betrayal. It is proof that the lawyer understands the actual dispute before attacking the other side's position. The rule would reduce caricature. It would force lawyers to separate emotional narrative from provable fact. It would help courts distinguish real risks from inflated fears, willful violations from reasonable explanations, and disputes that need orders from disputes that need perspective. It would also expose bad advocacy quickly. A lawyer who gives a sarcastic, distorted, straw man version of the other side's argument damages his or her own credibility before he even begins. This is not softness, it is precision. Family court needs more precision. A lawyer who cannot state the other side's argument probably does not understand the case well enough to argue his own. Understanding before arguing is not weakness. It is better judgment before advocacy begins.